Welcome to this introductory video on international humanitarian law. The first question we are going to answer in this video is, what is international humanitarian law? International humanitarian law, also known as the law of armed conflict, or jus in bello, or simply IHL, is a specialized field of public international law which primarily regulates the conduct of parties engaged in an armed conflict. IHL seeks to limit the consequences of armed conflict and aims to protect individuals, whether civilian or military, and whether wounded or active. To mitigate the effects of war, belligerent states and other armed groups engaged in a conflict are obliged to conduct hostilities within certain legal boundaries. IHL ultimately seeks to strike a balance between two main underlying principles: the principle of humanity and the principle of military necessity. The principle of military necessity permits the use of force that is necessary to achieve the aim of a conflict, but with limits to the expenditure of life and resources. The principle of humanity forbids the infliction of suffering, injury, or destruction which would be unnecessary to win the war. These two principles shape the entire body of law and are inherent in most of the more detailed rules stemming from the Geneva Conventions or the Hague Regulations. On the basis of the fundamental idea that military necessity needs to be balanced with humanitarian considerations, a few operational principles follow that must be applied by armed groups on the battlefield. These principles include those of distinction, proportionality, precautions, and the prohibition of unnecessary suffering. We will have a thorough look at the meaning of these principles at a later stage in this MOOC. Coming back to the first question, what areas does IHL cover? Generally speaking, IHL covers two areas or branches known as Hague law and Geneva law. Hague law restricts the means and methods of warfare. According to these rules, there are certain limitations upon the weapons that can be used in armed conflict, and hostilities can only be conducted in limited ways. This area is also referred to as the law governing the conduct of hostilities. Geneva law protects persons in armed conflict, such as military personnel and civilians who are not or who are no longer directly participating in hostilities. This branch of IHL dictates that fighters who have laid down their arms, medical personnel, detainees, civilians, and women and children should always be treated humanely, and stipulates certain standards on how to treat them. We also refer to this area as the law governing protected persons. These two branches of IHL draw their names from the cities where the respective treaties were initially codified: The Hague and Geneva. Hague law refers to the Hague Conventions of 1899 and 1907, and the laws on the protection of certain individuals were laid down in the four 1949 Geneva Conventions. A substantial part of IHL has been codified in the revised 1949 Geneva Conventions. Because nearly every state in the world has signed and ratified these conventions, they have become one of the most widely accepted international treaty bodies in the world. Both the Hague Regulations and the Geneva Conventions have been developed and supplemented by the additional protocols of 1977 relating to the protection of victims of armed conflicts. The protocols aim to combine these two branches of IHL, and as a consequence, the distinction between Hague law and Geneva law has since become less relevant. In addition to these key sources of IHL, there are other agreements which explicitly prohibit the use of certain weapons and military tactics, such as the 1980 Convention on Certain Conventional Weapons and its 5 protocols. Many provisions of IHL are now accepted as customary law, which means that they bind all states, regardless of whether these states have ratified the respective treaties. Let us now have a brief look at the history of IHL. War is as old as society itself, and even in ancient civilizations and religions, it was governed by a set of rules, sometimes expressed in codes of honor or local agreements. These ancient regulations, however, no longer serve their purpose when the Industrial Revolution led to the rapid rise of mass armies and powerful weapons. As a result, harsh practices took place on the battlefield, for instance in the American Civil War. In response to the large number of casualties, several humanitarian initiatives were sparked. In Europe, the birth of modern IHL was initiated by a young businessman from Geneva, Henri Dunant. In 1859, on his journey through Italy, Dunant witnessed wounded and dying soldiers on the battlefield of Solferino. This experience moved Dunant to begin a process that resulted in the creation of two key pillars of IHL. First, he initiated the establishment of an independent relief organization which could take care of the wounded and sick on the battlefield, the International Committee of the Red Cross, also known as the ICRC. As a second measure, he motivated the major powers at that time to adopt the original and first Geneva Convention for the amelioration of the condition of the wounded in armies in the field in 1864. Since then, IHL has developed into one of the most comprehensive and universally recognized bodies of international law. The final question we would like to answer in this lecture is, where does IHL stand in the international legal order? IHL is a specific field within public international law. It is the body of law that regulates the conduct of parties engaged in an armed conflict. One of its crucial characteristics is that IHL applies only if an armed conflict exists. IHL, however, does not regulate whether the use of force by one state against another is lawful. Whether the resort to force is lawful in the first place is regulated by a different body of law, the law on the use of force, also called the jus ad bellum. IHL applies to armed conflict, but it is certainly not the only body of law that applies in situations of war. Human rights law, for instance, applies in peace times but continues to apply in wartime situations. Human rights law, like IHL, strives to protect the lives, the health and the dignity of individuals, albeit from a different angle. While IHL and human rights law have similarities, these bodies of law also have important differences in their origins and scope of application. The final body of law we would like to cover is international criminal law. One method to enforce IHL, or in other words, prevent and repress violations of IHL, is the initiation of criminal prosecution and sanctions. IHL itself does not regulate in detail how such criminal prosecution and sanctions should be carried out when the rules of armed conflict are violated. This is the task of domestic and international criminal law. We will explore the enforcement of IHL through criminal law at a later stage in this MOOC. In summary, we have seen that IHL is a body of law that is specifically established to regulate the conduct of parties engaged in an armed conflict. By setting boundaries to the way that hostilities can be conducted and by providing rules on the protection of wounded soldiers, detainees and civilians, IHL aims to mitigate human suffering on the battlefield.